I'm Tricia Meyer. I'm the founder and managing attorney at Meyer Law. This is the fourth video on the 5 things you need to know and do if you're starting a business. Today, we're going to talk about something that is really important for you to understand as a business owner, and that's the importance of making sure that you own the intellectual property you think you own. Before we get started, please take a quick second to hit the subscribe button so you don't miss any of our important business tips and strategies to help you grow your business confidently and keep it running successfully. And if you find this information helpful, please hit the like button. All right, let's go. So, during the process of launching and scaling your business, you'll be creating intellectual property for your business, and you'll likely hire others to create intellectual property for you too. Examples of intellectual property include a logo, a website, a mobile application, a software as a service platform, marketing collateral, and even documents. So whether you enlist a graphic designer to create a logo and marketing materials for you, or developer to build your company website, mobile application, or a software as a service platform, you need to make sure that you have a contract stating that you are the sole owner of these creations. Basically, the law states that the creator of any intellectual property is automatically the owner of it unless it is specifically spelled out in writing to the contrary. So even if you pay someone for it, it doesn't mean that you automatically own it. If you don't have a document in writing that specifically says that you are the sole owner of the intellectual property that was being created, then the person that created it could claim that they only allowed you to use their creation and that you don't own it. And even worse, they could potentially have a claim against you for revenue generated by that IP. It's equally as important to make sure that if someone is creating any intellectual property for you and they are using certain portions of intellectual properties of others, that they have all the necessary rights to use that intellectual property and allow you to also use that intellectual property. Let's take your new business website as an example. Are you providing all the images and written content for the site, or is the developer providing it? If the developer is providing the images, for instance, then you'll need to make sure that they have the rights to use the images and that they can pass on that license to you. If a license is passed to you, then what rights and responsibilities do you have under the license agreement? If they're creating the content for you, it's equally as important that you own the rights to that content. These are all important things to consider. You need to have solid contracts in place to protect your intellectual property and prevent unwelcome and unnecessary surprises down the road. And those can be costly. Of course, there are many terms that you should include, and one of the terms is wording that states that you are the sole owner of the intellectual property created. The contract should also require them to get your approval prior to using any third-party intellectual property so that you can make sure that you're okay with the terms and conditions that you're going to be bound to. Even if the person creating the intellectual property is a family member or a friend, you still have to get it in writing. Not only will you be protected if things don't go well, but often a well-drafted contract will prevent things from going south in the first place by clarifying expectations and preventing misunderstandings. It is critical to protect your intellectual property and your business. If you need any help figuring out how to best protect your intellectual property, or if you have any questions about the contracts that are necessary to protect your intellectual property for your business, feel free to reach out. We're always here to help. Thanks for watching.